Before the court gets into plea discussions, the judge signals concern about behavior patterns. This matters legally. Judges don't just sentence crimes. They assess whether conduct is isolated or part of a deeper issue that could require supervision or treatment.
In 2024, David Calhoun, who's your executive at the time, got $32.8 million in compensation in a year. $32.8 million. That was a 45% increase over the previous year. At that point in time, your planes were literally falling out of the sky in pieces, and you weren't paying your workers. Is that fair?
Senator, I'm not in a position to comment on executive compensation.
Well, you're the chief labor counsel.
I am the chief labor counsel.
Were you involved in the settling the machinist strike in Seattle, I think it was? Yeah, congratulations to all the nominees. Thank you for being here. Mr. Mayor, let me start with you. I represent the state of Missouri here in the Senate. In Missouri, in the city of St. Louis, there are 3,200 machinists, a little bit more, who are currently on strike. The overwhelming majority of these folks are Missouri residents. They're striking against your company. You're the chief labor counsel. What do you think the fair outcome to this dispute ought to be?
Thank you, Senator, and good morning. Let me start by saying I'm not here as a representative of Boeing.
But you're employed by Boeing.
Yes, sir.
How many years have you been employed by Boeing?
Just over 3 years, sir.
Mr. Mayor, is your microphone on? If so, could you pull it a little bit closer?
Sorry, my first time here. I've been with the company about 3 years.
So my question is what do you think is a fair resolution to this dispute? And we've got 3,000 plus Missourians who are currently effectively out of a job. They haven't had a significant wage increase in years. They need to be able to afford to pay rent, to put food on the table for their families, get their health care. I mean, is your company going to do right by these workers? You can understand why I've got a significant interest in this. This matters a lot for my state. It matters a lot for these workers and their families. There's a lot of people.
Certainly, Senator, I agree. It matters a lot. It matters to our hardworking employees, our hardworking the members of the IAM. I know the concept of fairness is an elusive one. What I will tell you is that the union and the company reached an agreement at the end of July. I'm not, as I said earlier, I'm not involved in that negotiation.
Well, I mean, is the concept of fairness you say is elusive? Let me ask you this. In 2024, David Calhoun, that wasn't a question, I'm just quoting you. In 2024, David Calhoun, who's your executive at the time, got $32.8 million in compensation in a year. $32.8 million. That was a 45% increase over the previous year. At that point in time, your planes were literally falling out of the sky in pieces, and you weren't paying your workers. Is that fair?
Senator, I'm not in a position to comment on executive compensation.
This is an important legal safeguard. When co-defendants share one attorney, the court must warn them about conflicts of interest. If one defendant's defense hurts the other, the lawyer could be ethically barred from continuing. That warning protects future appeals.
You're the chief labor counsel.
I am the chief labor counsel.
Were you involved in the settling the machinist strike in Seattle, I think it was?
Yes, Senator, I was involved in that negotiation.
Okay. Do you remember what the contract was you finally gave the Seattle machinists?
I remember parts of it. Yeah, I can't.
Wage increase, 38% general wage increase over 4 years, plus the option of a $12,000 one-time ratification bonus or a $7,000 ratification bonus and a $5,000 401k contribution. Does that sound roughly correct?
That sounds roughly correct.
Okay. Why wouldn't you just do that for the folks in St. Louis?
Senator, every negotiation is different.
Well, plainly so, because what you're offering to my constituents is a fraction of that, and I guess I just don't understand why. I mean, is it that what's different about the folks in Missouri?
It's not a question of difference about the folks in Missouri. It's a question about.
You just said a minute ago, fairness is elusive. I mean, it does seem to be elusive for the Missouri strikers.
Senator, fairness is a matter of what the parties ultimately agree to. Again, as I stated earlier, the union and the company came to reach an agreement. The union felt that the agreement that we reached at the end of July, and
which the workers didn't ratify, right?
This is all public.
Here's what you've offered currently, you've offered Missouri workers a wage increase that's 16% below what you offered the Seattle workers. You're offering them bonuses that are thousands of dollars below, $8,000 or $10,000 less, with far fewer other benefits. I guess I just don't understand. I mean, what's different about these Missouri workers? I mean, there's only 3,000 of them, although that's a lot of people. It was 33,000 in Seattle. How is this going to end? Are we going to get to a fair resolution here where these workers get paid on terms equal with other workers at your company across the country? Or are these folks going to be permanently replaced by non-union workers?
Senator, there was an offer on the table. The employees voted it down, as you stated.
Right. That was months ago. I'm asking about now. What's going to happen going forward?
The employees are engaging in protected activity of striking, and ultimately the parties will negotiate a deal. I don't know how it's going to end. I'm not.
Do you think it would be fair for the Missouri workers to be paid what the Seattle workers are paid?
Senator, there are a number of factors.
A no-contest plea isn't a loophole. Legally, it functions almost the same as guilty for sentencing, but it prevents the defendant's own words from being used in future civil cases. That distinction is strategic and very intentional.
That come into play with how employees are paid and the general.
My time has expired, Mr. Mayor. I'll have more questions for you. I have to tell you, with 3,000 plus members of residents in my state on strike, unable to work, unable to get health care, while your CEO is getting paid $30-some million, that fairness may be elusive, but that doesn't look like fairness to me. Thank you, Mr. Chairman.
What's your profit margin, Ms. Kirkpatrick?
It's circa 50%.
Mr. Sheedy?
Slightly higher.
It's higher than 50% profit margin?
Slightly higher than MasterCard, yes.
Yeah, that's incredible. 50% profit margin. That's absolutely unbelievable. What's the answer to the Walmart question, by the way, that Senator Welch posed to you? What's Walmart's interchange fee that you negotiate with them?
I don't have it with me today.
You don't have any idea whatsoever? No. Is it higher or lower than 2.5%?
Walmart negotiates their rates based on the business that they do with us.
Meaning they're big. They're really big. They're gigantic. So they get a better deal than Mr. Callahan or most small businesses in Missouri. Is that what you're telling me?
Yes, Senator. We have volume discounts that we offer to some merchants. I suspect Walmart is one of them. I don't believe that it's commercially unreasonable to get an arrangement where, in exchange for more volume, a merchant can qualify for lower rates?
Well, I'm sure it's not commercially unreasonable for Walmart, or certainly it's in their financial interest and in yours, but I doubt it's in Mr. Callahan's financial interest. And my question to you, Mr. Callahan, is when you've got Walmart and other major competitors getting charged much less than you are, why in the world would you stick with these guys? Why is it that small businesses continue to use Visa and MasterCard when you're getting charged so much more?
It's in my opinion, it's a matter of convenience for the customer, and customers matter to our business.
Maybe is it because that Visa and MasterCard are effectively monopolies? They control 80% of the market.
Certainly part of the
80% of the market. I'm just having a hard time understanding, Mr. Sheedy and Ms. Kirkpatrick. You have a business model. You're making over 50% profit margin. You are able to give the shaft to small businesses. Estimated cost to Missouri businesses from these fees is $1.5 billion. That's with a B, billion dollars a year. Why aren't all of these businesses running away from this model? Because they don't have a choice, because you control so much of the market. This is classic monopolistic behavior, and yet your testimony here today is you don't want any competition. You have 80% of the market, but you don't want any more competition.
When sentencing is delayed or preceded by interviews, judges gain leverage. A pre-sentence investigation gives the court a full profile, work history, risk level, restitution ability, and often determines whether probation stays probation.
I'm having a hard time finding that position defensible, let alone sympathetic. It's unbelievable the amount of money that you're making. It's unbelievable what you're charging small businesses and consumers, and yet your testimony is, please, we can't possibly have any competition. Let's talk about what you're doing to consumers who hold your cards Last year, as I understand it, there were 726 million Visa and Mastercard credit cards issued in the United States. That's about 2 for every 1 person in the United States of America. Do either of you know how much debt is owed on your networks, Ms. Kirkpatrick?
We're not the bank, so we don't have visibility into that information. We also don't generate revenue from interchange.
Oh, okay, you have no idea. Mr. Sheedy, do you know?
I don't know.
Well, let me help you out. Let's have a look. It's $1.17 trillion. $1.17 trillion is what consumers now owe on your credit card networks. Do either of you know what the average interest rate is on your networks? Ms. Kirkpatrick?
Oh, Senator, we're not the bank. We don't set the interchange.
I know,
we don't set the
benefit
rates
from it, and you know. Do you know what it is? This is your business model.
We don't collect revenue from interest rates.
Do you know?
I don't, Senator.
I mean, do either of you read the newspaper? Forbes magazine just estimated last week that the average credit card APR in your networks is 28.75%. Average. 29%, let's call it. 29%. It's nearly doubled in the last 4 years. That is astounding, absolutely astounding. And you just testified a second ago that you've got more than 50% profit margin, and yet your testimony here today is you can't possibly survive if there's any competition. How can that be true? How can that be true? You've got debt like we've never seen before in American history. Your profit margins are as higher than they've ever been. You have 80% of the relevant market in the credit card interchange fees that we're talking about, and yet you couldn't survive if there's any competition? What am I missing?
This is the moment judges focus on most. When adults with stable lives commit retail fraud, courts look for motive, stress, addiction, or calculated behavior. The judge isn't fishing. He's deciding how much supervision is necessary to prevent repeat offenses.
That's not a rhetorical question. How is it that you can't do any better?
Senator, we like competition very much. As my colleague from MasterCard mentioned, we don't loan money to consumers. That's the job of the banks. I will say, as it relates to small business, we care very much. And the pandemic was difficult on small business more than anyone. In 2022, we lowered rates for 90% of small businesses in the United States. I also think that many of the security and the digital features that have been put in the network help small business.
Wait a minute, but wait a minute. My time is almost expired. I don't mean to interrupt you. I'm sorry to interrupt you. But hold on just a second. You've increased the swipe fees consistently in the last few years. You've raised them. Even as your network has expanded, even as your profit margins have gone up, you've raised the swipe fees. And in terms of competition, you are paying competitors not to enter the market. The DOJ lawsuit says that you threaten retailers with staggering financial penalties. That's a quote, staggering financial penalties if they use a competitor, and you're paying Apple and Square and others not to compete in your market. You've got 80% market share, and you are paying off would-be competitors not to come into the market while you charge people like Mr. Callahan, who knows how much more than big entities like Walmart. I mean, this is just classic collusive monopoly behavior. And your testimony is you can't accept any more competition. I agree with one thing that my colleagues down the dais have said, which is that this is not a sustainable situation. It is not sustainable. This has to change. $1.17 trillion in debt, this has to change. And I'll just end with this, Mr. Chairman. I thought one of the best proposals that the President-elect Trump, made during his last campaign, his most recent campaign, was to cap the interest rates of credit cards. So we could do that. We could do this and that. I think it's a great idea. I don't know why 30% interest rate should be charged on debt like this. I don't understand it. And I don't understand why you won't accept the smallest modicum of competition when it comes to these retailer fees. And I'm just here to tell you, this will not stand. Thank you, Mr. Chairman.
Let's break down what this case really teaches, because on the surface this looks like a simple retail fraud plea, but legally it's much more instructive. First, the structure of the plea matters. Both defendants entered no contest pleas, which allows the court to move forward without forcing them to verbally admit facts. That protects them from potential civil liability while still holding them criminally accountable. Second, restitution is prioritized over punishment. Notice how the judge repeatedly emphasizes restitution first, before fines or costs. Under U.S. criminal law, victims are made whole before the court collects its money. That's not discretion, that's policy. Third, joint and several liability is key. When restitution is joint and several, the court can collect the full amount from either defendant. This prevents defendants from shifting responsibility between themselves and ensures the victim gets paid. Fourth, sentencing philosophy. The judge chooses delayed sentencing for one defendant and work program days instead of jail for the other. That reflects proportional justice, punishment tailored to risk, history, and rehabilitation potential. Fifth, the judge's questioning about normal behavior is preventative justice. Courts don't just punish past actions. They assess future risk. Stable employment, family ties, and absence of substance abuse all influence outcomes. Finally, this case shows how courtroom efficiency works. The judge manages time, clarifies facts, verifies consent, and closes legal loopholes, all while creating a clean record that withstands appeal. This is how lower-level criminal cases quietly shape lives, not through drama, but through structure, accountability, and judicial discretion.